We had a 16-year-old client from Guatemala. She had concerns with gangs in her community, and she also faced physical attacks and threats because of her indigenous status and her indigenous culture, as well as her physical appearance. She had a darker complexion in relation to most of the people in her community, and she faced a lot of discrimination because of that. She originally entered the U.S. with a parent and was placed in an MPP program, which basically means that they were sent to wait in Mexico while the judge decides their asylum claim. At some point, they returned back home, and then the minor returned to the U.S. and she entered alone. And so at that point, she was designated an unaccompanied minor, and she was placed in or care here in El Paso. When we encountered her, she had an MPP removal order because the judge had already ordered her and her mother removed. They had missed a hearing, and in their absence, they were ordered removed in absentia. And that's something that's actually not too uncommon with the MPP program, unfortunately. And a lot of times when these children then enter alone, they have these removal orders that then impedes their immigration case and our ability to kind of help them. This client already had this removal order, and so at this point, the shelter was not willing to reunify her with her relatives.
The minors are entitled to new deportation proceedings, new removal proceedings, once they enter alone, unaccompanied. If ICE, Office of Chief Counsel, and the immigration courts, they don't recognize this statute as requiring new proceedings. They interpret it as the MPP proceedings are sufficient. So it's a difference of interpretation of the federal statute. This is actively being litigated in a DC court right now.
We filed a motion to reopen her immigration case, as well as a motion to rescind her removal order. And what that did for her, it gave her an automatic stay of her deportation, and that basically bought us 3 or 4 weeks. Unfortunately, that order was denied by the immigration judge, and she was not reunified during that 3 or 4 week time period. We filed an appeal with the BIA, which is the Board of Immigration Appeals in Virginia. A lot of work went into that because we're located, of course, in El Paso, and that appeal has to be filed in person or by mail. And since it was an emergency situation, it was too late to send it by mail, so we actually hired a courier service to then print the documents and deliver it in person to the Board of Immigration Appeals. We also filed an emergency stay for her deportation with the Board of Immigration Appeals, but was unfortunately denied shortly after. We also completed an asylum application with her as well. We requested that she receive a fear interview prior to any further efforts to deport her. Because she did complete an asylum declaration, she did make claims of fear. She never had an opportunity to have her fear evaluated before either an asylum officer or an immigration judge. After she was picked up by ICE, we then worked to try to find other ways to help her. We contacted the U.S. Attorney's Office to try to see if we could negotiate her placement. Unfortunately, she had already been transferred out of El Paso to another city in Texas. And so we then looked for local agencies who could help us and try to assist her, try to get her signatures to complete her asylum application. But then she was transferred out of state. We then worked with an attorney in that state who was licensed in that state to file a temporary restraining order for her, as well as writ of habeas corpus. Habeas corpus basically means to produce the body. We're asking the judge to release her from being deported, in a sense, and to return her. Unfortunately, the morning after those documents were filed, the temporary restraining order was denied. At that point, the minor was still scheduled to be deported, and at some point, several days later, she was then sent to another city where she was ultimately deported at that point.
In the past, we were able to work with the ICE Office of Chief Counsel and work with the immigration court and work with the shelters to get the children out of the MPP program. For whatever reason, in this case, ICE changed their posture and did not want to help us reopen her MPP case that was closed. If it becomes the new norm that ICE is going to proceed to removal of unaccompanied children who were in the Migrant Protection Protocol MPP program, then it's going to take a lot of resources and a lot of time to protect these children from that process. We'll probably see more of this. It's troubling right now with the pandemic. In this case, the girl was moved to different states and different cities, given that travel is discouraged during this time period. And she was exposed to these different places. Also, in this time of pandemic, we're seeing fewer cases because the Border Patrol is expelling migrants without processing them. They're including unaccompanied children in that group of expulsions. The children aren't getting through. They're not finding the refuge that they're seeking. I'm not sure what the future holds. I have a feeling that we've got a lot of work in store helping these children, but that's our job and that's what we do.